Good morning. Is everyone able to hear me well?
Loud and clear, Judge.
Thank you. All right, is courtroom 2 on the line?
Can you say it again, Judge? I think we just lost
Judge,
it.
there, if you can give us a couple of minutes, the deputies will bring some of the folks in and.
Okay. Hmm.
We're ready, Judge.
All right, thank you. Good morning, everyone. This is the state all-purpose calendar in the State Court of Fulton County, Georgia. I'm Judge Melanie Williams, and at this calendar today, we will address a variety of matters, set bonds, accept pleas, and address matters as necessary. All defendants, please pay close attention. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to counsel at these proceedings today. As you can see, I am conducting this hearing by video. That means I'm not there in person with you. This particular proceeding is being broadcast over the internet as a live stream. That means any member of the public can log on and watch this. When I ask if you understand your rights, this is what I am referring to. Who do we have first at courtroom 2? Before I do that, are there any announcements from any of the defense attorneys that I should be aware of? And particularly regarding interviews. Okay, let's proceed. Who we have with you, Mr. Haddad?
Position 37 and 38, Smith.
Okay, and I have that this is a plea.
That
Is
is
that correct? Okay, Mr. Smith, your case is 22 CR 0000327 Forgive me of that. In this case, you are charged with theft by receiving stolen property. Do you understand your rights?
Yes, ma'am.
All right, Mr. Nixon, if you would please give us a very, very brief factual basis here, as well as the state's recommendation.
Yes, Your Honor. With regard to the factual basis, the defendant here did receive retained stolen property. Is Alcatel 7 cell phone on the property of Miles Tibbs, value less than $1,500, and he received that property from his gang associates. The state is going to ask for recommend 12 months to serve 22 days, credible time served 11 days, and that's from January 23rd, 2022 to January 24th, 2022, and then from May 28th, 2025 until today. Balance probated, anti-theft course, 40 hours community service, no further contact with Miles Tibbs, and that last name is Tibbs, and a $500 fine. In reference to the FTA, the state will don't process under FTA upon pleading to the underlying offense, and the state would ask that the defense stipulates venue, factual basis, and identification for the purpose of this plea.
All right, do you still stipulate, Mr. Haddad, and was that your understanding?
Yes, Judge, we stipulate, would ask the court to follow this state's recommendation. I'd request the court to consider a non-reporting upon completion of all the conditions or waiving the first 2 months of probation fee, Judge.
Okay. All right, Mr. Smith, I'm going to place you under oath. Please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking the plea?
No, ma'am.
And you understand by taking the plea, you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you further understand the requirements, including the class you have to take, the community service hours, the fine, that you are to have no contact with Mr. Tibbs, but you should not have additional time to serve in the Fulton County Jail on this charge. You understand that?
Yes, ma'am. Understood.
All right. As to the charge, Mrs. Smith, of theft by receiving stolen property, how do you plead this morning?
Guilty.
I accept your guilty plea. Once you've completed all the requirements, your probation will go non-reporting, all right?
Ma'am.
Is there anything additional from state or defense?
No, Judge, thank you.
Thank you.
No,
Best of
no.
luck to me, Mr. Smith. We don't want to see you back here. Take care.
Yes, ma'am.
Position number one, Alexander. Come on, Alexander.
All right, I have it. This is a negotiated plea as well.
That's
Is that
correct, Judge.
correct? Thank you, Mr. White. Mr. Alexander, your case is 25 CR 002935A. You are charged with criminal trespass in this case. Do you understand your rights?
Yes, ma'am.
All right. Let's see. This is your case, Ms. Falk? If you would give us very briefly the factual basis and the state's recommendation.
Yes, Your Honor. The state's recommendation in this case is going to be 12 months served, 28 days, credit for time served, 14 days. Balance suspended, stay away from the Central Library at 1 Margaret Mitchell Square in Atlanta. The credit for time served is from May 23rd of 2025. The defendant did go to that location, the library at 1 Margaret Mitchell Square, and was told to leave repeatedly. He failed to comply and then was placed under arrest. That's all for the state. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
So
All right, you so stipulate, Ms. White, that was your understanding?
that's correct. Nothing further.
Thank you. Mr. Alexander, please raise your right hand. I'm going to place you under oath. Do you swear or affirm that the testimony you give today for the very limited purpose of taking a plea will be the truth to the best of your knowledge and is given under the penalty of perjury? Thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand by taking the plea, you're giving up your right to trial by judge or jury?
Yes.
You fully understand you cannot go back to that library at all, but otherwise the time you served in the Fulton County Jail should close your case. Do you understand that, Mr. Alexander?
Yes, I do.
All right. As to the charge of criminal trespass, how do you plead?
No, no.
I don't think we discussed the no love plea.
We did not agree to an LO plea, Your Honor.
Judge, that's the first I've heard of it. I mean, any harm, no.
Oh, I think he said guilty, Judge.
Okay, how do you plead, Mr. Alexander?
Guilty.
I accept your guilty plea. Is there anything additional, Mr. White or Ms. Falk?
No, Your Honor.
Nothing further, Judge.
All right, best of luck to you, Mr. Alexander. Don't go back there. They don't want you there, okay? Take care. All right, who do we have next?
Do Mr. Joseph Wheat, I'm not sure his position number.
What's the last name?
Wheat, Joseph Wheat.
No, that's position 44.
Okay, I have it. This is a negotiated plea as well. Is that correct?
That is correct, Judge.
All right, Mr. Wheat, your case is 25 CR 002901D. In this case, you're charged with trespass, shoplifting, and possession and use of drug-related objects. Do you understand your rights today?
Yes, ma'am.
All right. May I please have the state's recommendation as well as a very brief factual basis, Mr. Nixon?
Yes, Your Honor. This occurred on May 21st, 2025. This was against a criminal trespass, theft by shoplifting, and a possession charge. Looks like the defendant at 2 p.m. stole some Gatorade from the Family Dollar at 3721 Campbellton Road. And when he was arrested, after the search incident to arrest, they found a crack pipe. The state's recommendation is 12 for count 1, 12 months to serve concurrently with count 2. For count 2, it'll be served 60 days, credit for time served credit for time served 16 days, and that's from May 21st, 2025 until today. Alcohol drug evaluation treatment, balance probated, anti-theft course, 40 hours, community service, stay away from the Family Dollar located at 3721 Campbellton Road Southwest. And as for count 3, 12 months to serve concurrently with count 2. And the state's going to ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
Do you so stipulate, Mr. Haddad?
Yes, Judge. Nothing else to add.
All right, Mr. Weed, I'm placing you on oath. Please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
And you fully understand that the requirements of the sentence, including the evaluation you have to undergo, an anti-theft course you need to take, 40 hours of community service, and that you must absolutely stay away from that location. How many additional days will he have to serve in the Fulton County Jail if he accepts this today?
I believe it boiled down to 14 days, Judge.
Okay, and you understand you would have some additional time to serve in the Fulton County Jail, Mr. Wheat?
Yes, ma'am.
And you understand all those requirements and you still wish to move forward with the plea?
Yes, ma'am.
And you understand that taking a guilty plea may affect other aspects of your life, such as employment, probation, immigration, or things your attorney and I may not be able to anticipate?
Yes, ma'am.
All right, as to the charges previously listed, Mr. Wheat, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything additional from the state or from the defense?
No, Judge.
All right, best of luck to you, sir. That concludes your case.
Next is position 6, Mr. Cowan. Yeah.
Okay, I have that this is a non-negotiated plea, so can I please have, I'm sorry, let me give Mr. Cowan his rights first. Mr. Cowan, your case number is 19 CR 001535C. In this case, you're charged with theft by taking. Do you understand your rights today?
Yes, ma'am.
All right, this is a non-negotiated plea still, Mr. White?
That's correct, Judge.
All right, Miss Washington, I think I saw you on the line. Can I please have the history for this defendant?
Yes, Your Honor. There are 32 arrest cycles out of North Carolina. And in Georgia, there are 26 arrest cycles. And also in Florida, there are 3 arrest cycles.
Okay.
In Florida, I'm sorry, in North Carolina, there was a 99 felony conviction for larceny, breaking, and entering. In 2019, out of Georgia, there was a felony conviction for possession of meth and a misdemeanor conviction for possession of drug-related objects. There was an arrest in 2018 for theft by taking. That case appeared to be dismissed. A 2018 drug possession of meth felony conviction. In 2015, there was a misdemeanor conviction for theft by conversion, 2 counts of theft by conversion, and 1 count of theft by taking, which was a felony. There are other misdemeanor charges and felony convictions for drugs in 2015. There was a 2012 theft by receiving stolen property and also a fleeing arrest that resulted in a conviction.
That's good, Miss Washington. Thank you.
Okay.
Thank you. I appreciate that. All right, Miss Falk, please proceed.
Yes, Your Honor. If I may ask, PD White, is the objection to the community service, the fine, the anti-theft course, or all 3?
All 3.
Okay. So Your Honor, this incident happened back in December 5th of 2017. Officers were called out to Derrick Road at Derrick Industrial Boulevard. The victim, Mr. Rotten, stated that his son watched the defendant get into his 2003 Chevrolet Trailblazer. Mr. Rotten had left a key inside the vehicle. The defendant found the key and started the vehicle. He then drove off the property. Mr. Rotten gave chase in another vehicle, and the vehicle ended up at 5752 Gray Wind Trail. Mr. Rotten then caught up to his stolen car and the defendant at Derrick Road at South Fulton Parkway, and the defendant was apprehended at the scene. So the identification, obviously we're asking for them to stipulate, but I don't believe the identification is an issue. The reason for the state's recommendation, we understand that this case is a 2017 case. The defendant had a warrant issued for his arrest in May of 2019. That warrant has been outstanding for the last 6 years. The state, doesn't know where he was for the last 6 years, but this warrant has been pending for that amount of time. I will say that the defendant's history is what caused the state to request anti-theft course, 40 hours of community service, and $500 fine. We did take into consideration the age of the case, which is why we offered a time served instead of something more severe, because given his history, he actually would have been, if this case had been a 2020 or above case, we would have recommended more jail time, to be quite frank. We would at this time like to sound for Mr. Rotten, and we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
All right, thank you. Mr. White?
Your Honor, Mr. Cowan has actually been in prison for the last 6 years, 2 months, and 9 days. That is the basis of us asking for just a straight time served plea. He would like to move back to North Carolina. He has family there. And considering the length of time that he's been in prison and the age of this case, I think any conviction at this point is kind of a gift to the state. Likelihood of proving this at a trial is minimal. But anyway, we're just asking, based on the fact that he's been in prison for so long, that's why it's just now coming to court. And we'd like him to move back to North Carolina and be with his family where he's support. He has he did have a drug issue for a period of time, but that appears to be behind him. So we think North Carolina, not on probation here in Georgia, is the best course for all involved.
Okay, let me sound for Mr. Rotten. Is Mr. Rotten present? All right. If he takes this plea today, Mr. White, I will strike the anti-theft course, the 40 hours community service, and the fine. Does he wish to still take the plea at this time?
He does, Your Honor. Thank you.
All right, Mr. Cowan, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand by taking a guilty plea, you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand that taking a guilty plea may affect other aspects of your life, such as employment, probation, immigration, or other things that I might not be able to anticipate?
Yes, ma'am.
As to the charge of theft by taking, Mr. Cowan, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from state or defense as it pertains to this case?
No, Your Honor.
No, Your Honor.
All right. Best of luck to you, Mr. Cowan. Have a good day.
Thank you.
Judge.
Yes.
So is that still going to be balance probated and no further contact on this case?
Yes.
Okay, thank you.
Wouldn't it just be balance suspended since there is no
Well,
due on probation? The stay away still is in effect.
the stay away will still be in effect. Yeah. Okay. We can make it balance suspended.
Okay, thank you.
All right. Who do we have next?
Good morning, Judge. I have position number 19, Ms. Jordan.
And has ACDC heard their rights?
No, Judge, if you could please tell them their rights. Thank you.
All right. Good morning, all defendants. Please pay attention. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. As you can see, I am conducting this hearing by video. I am not in person with you. When I ask if you understand your rights, I'm asking whether you understand those rights that I've just explained and how I'm conducting the hearing. Please be advised that the proceeding is being broadcast over the internet as a live stream. It's also being recorded. Ms. Jordan, your case is 24 CR 004866Y. You are charged with harassing communications. Do you understand your rights today?
Yes, I do.
All right, thank you. I have that this is a negotiated plea. Is that correct?
Yes, Judge, and if I may, Ms. Jordan, the state agreed to recommend time served in your case, okay? So the recommendation is time served.
Okay. All right, Ms. Falk, please proceed.
Yes, Your Honor. As PD Haddad said, the state's recommendation on this case has been modified from the original recommendation on the calendar as follows. The state's recommendation is 12 months, served 20 days, credit for time served 10 days. That is going to be from July 19th, 2024, 1 day, and then May 28th, 2025 until today. The requirements are that the defendant stay away from Emory Midtown Hospital located at 550 Peachtree Street Northeast unless for medical treatment. No further contact with Emory Hospital by phone, email, text, or in person. MHET and 40 hours of community service. The defense has also agreed as part of the modification to not request early termination or non-reporting. This incident happened from October 25th of 2022 to October 30th of 2022 at Emory Hospital. The defendant called repeatedly 113 times between those dates, harassing and threatening the operators, threatening to kill them, just repeated persistent threats. When the police did intervene and asked Ms. Jordan to stop calling, she cursed out the officers, refused to stop calling, which then led to her arrest. We do ask the defense to stipulate to venue factual basis and identification for the purposes of this plea. That's all for the state.
You so stipulate, Mr. Haddad, and was that your understanding?
Yes, Judge.
All right. Ms. Jordan, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
So the car is over there, one over here, okay?
Is that a yes, Ms. Jordan? I need you to speak loudly.
I do.
All right, thank you. That was perfect. Thank you. When I ask you to answer, please speak as loudly as you can, okay? We just need to make sure the record is clear and that you want to take a plea today because pleas are optional, okay? Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
You understand you're giving up your right to trial by judge or jury?
Yes, I do.
And you fully understand the requirements. You need to stay away from the Emory Midtown Hospital unless you're getting some medical treatment. You're not supposed to have contact with the staff there by phone, email, or text. You're going to complete some community service and you're going to undergo an evaluation. Do you understand all of that, Ms. Jordan?
Yes, I do.
Okay. Otherwise, you should not have additional time to serve in the Fulton County Jail. Do you further understand that taking a guilty plea, it may affect other aspects of your life, such as employment, probation, immigration, or other things that your attorney or I may not be able to anticipate? Do you understand that, Ms. Jordan?
Yes, I do.
All right. As to the charge of harassing communication, how do you plead?
I plead guilty.
All right. Ms. Falk or Mr. Haddad, is there anything additional?
No, Judge.
All right, I accept your guilty plea, Ms. Jordan. Take care. Have a good afternoon. All right, who do we have next?
Your Honor, as far as we're ready for ACDC, Judge. The only person I need to still speak to is Ms. Rouse, but the other females that are pleased, Judge, I'm ready.
All right, there's also a Yehuda Bruck Esquire. Who is your client?
I'm sorry, it's Anthony. I came there in person, so it's Anthony Morris.
Is Mr. Morris present at the jail so we could take that position?
He's not in custody. He's out of custody. I actually just met him at the courthouse thinking it was in person.
Oh, okay. Well, if he's not in jail, unless he intends to take a plea today, I think that there's nothing further for you or your client at this time.
So he'll receive a future court date?
Yes, make sure your address is and that you have a proper entry filed into the case, okay?
Thank you, Your Honor.
All right, take care. Have a good day.
Your Honor, just so you know, that's position 27 and 28.
Yes, thank you. All right, who do we have at ACDC?
Judge, that's Ms. Rouse. That's the only one that I needed to speak to.
Oh, okay, that is
Okay.
the person. Can we call over? Is that possible?
We can, Judge, unless the court wishes for me to handle the other,
Oh, it
Yeah, we
doesn't, however y'all want to do it, I'm fine with that.
Position number 30, Ms. Morris.
I have that this one is a negotiated plea,
Thanks, Judge.
and she's position 29 and 30, correct?
That is correct.
Yeah, 29 and 30. Yes, Judge.
All right, Ms. Morris, you have two cases today. Your first one is 24 CR 003240E, in which you were charged with reckless conduct, obstruction, and failure to use a crosswalk. Your second case is 24 CR 008085E. In that case, you're charged with disorderly conduct, simple assault, and terroristic threats. Do you understand your rights this morning? Is that a yes? I just need you to speak as loudly as possible, okay?
Yes, ma'am.
Thank you. I appreciate that, Ms. Morris. All right, Mr. Nixon, will you please give me the state's recommendation, as well as a very, very brief factual basis, as brief as you can make it. Thank you.
Yes, Your Honor. With regard to the reckless conduct, obstruction, and failure to use crosswalk on May 23rd, 2024, the defendant was seen by plainclothes officers walking in the middle of the road. The defendant had an unsecured handgun in her waistband, and she then walked to a public park with a large amount of children and civilians. The defendant saw officers approaching. She began to run through the park with the handgun, and then abandoned the handgun and ran from police. With regard to disorderly conduct, simple assault, terroristic threats, on August 31st, 2024, this was at the Exxon gas station located at 1570. The defendant was attempting to purchase some tobacco from the store. The defendant became agitated and began knocking over items in the store. Then confronted once the victim confronted the defendant, she pulled out a firearm with an extended clip. For count one, I want to make sure I have this correct. Here's just one moment, Your Honor. For the reckless conduct, obstruction, and failure to use crosswalk, the state is recommending 12 months. For count one, 12 months consecutive to the 24 CR 008085E charge there, balance probated, a stay away from 400 Merritt's Avenue, Northeast, Atlanta. That's the Central Park and Exxon at 1570 Monroe Drive. No further contact with, I'll spell the name, FIROZ, Ali, ALI, BABU. And that very last name is AERASHIYA. And of course, the state would ask that the court sound for this victim when appropriate. The state is further requesting 12 weeks anger management, 40 hours community service, and no firearms. As for count two, the state is recommending time served 362 days, credit for time served 181 days. Now, this is from May 23rd, 2024 to May 25th, 2024, as well as December 10th, 2024 until today. And as for count three, state is recommending time served 362 days, credit for time served 181 days, May 23rd to May 25th, 2024. And again, December 10th, 2024 until today. As for the disorderly conduct, simple assault, and terroristic threats, the state is recommending, as for count one, 12 months served concurrently with count two. For count two, 356 days, credit for time served 178 days. And that's from December 10th, 2024 until today, balance probated. As for count three, that'll be 12 months to serve concurrently with count two. And the state would ask that the defense stipulate to venue, factual basis, and identification for the purposes of the plea.
Okay. So for count 3 on position 30, there was also some requirements, but those are the same requirements that they appear to mirror the requirements for count 1 on the other case. Is that correct? Other than the victim's name is different?
Yes, Your Honor.
Or was the state asking for 80 hours of community service, or will the 40 hours that she completes go to both cases?
And
Am
you
I
said
making
referencing
sense? I'm just
count
making
four.
sure. I'm making sure because I see the requirements listed for both cases. I'm making sure that the state is only asking for 40 hours community service and 12 weeks anger management total for both cases. Is that correct?
That was
Correct, correct.
Okay. All right, Mr. Haddad, that was your understanding. And do you stipulate to those 3 elements?
we stipulate, Judge, in essence, it's a time served sentence followed by probation. However, just so the court is aware, Ms. Morris is still being held on felony charges, but upon release, I've explained to her that she needs to report to
To
probation.
do those. All right, understood. All right, I'm gonna sound for both of the victims in this case. Last name is Arashiva. All right, hearing none, Ms. Morris, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
I do.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand by taking a plea, you're giving up your right to trial by judge or by jury? You said no, you are giving up your right to trial. Do you understand that? Like you're
Oh,
not gonna
yes,
have any
ma'am.
other court dates about this. You understand that?
Yes. Yes.
And you fully understand the requirements of the sentence, including the fact that you need to take 12 weeks of anchor management. You can have absolutely no firearms, no contact with that particular store employee with the last name Arashiva, and you cannot return to that location on Monroe Drive. Do you understand that?
Yes, ma'am.
And are you satisfied with your attorney's representation, and have they fully explained the sentence to you?
Yes, ma'am.
All right. And you understand that taking a guilty plea can affect other aspects of your life, such as employment, probation, immigration, or other things I may not be able to anticipate. Do you understand all of that?
I didn't hear you.
What I'm saying is, if you take a guilty plea, it may affect your ability to get a job, other cases you may have, or if you want to immigrate to another country. Do you understand that? There may be things that this case affects that we can't anticipate. Do you understand that by taking a guilty plea, it may affect you in other ways?
Yes, ma'am.
All right. As to the charges previously listed, Ms. Morris, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional, Mr. Nixon or Mr. Haddad?
No, Judge.
All right. Best of luck to you, ma'am. That concludes your case.
Position number 40, Thomas.
All right, I have that this is a negotiated plea. Ms. Thomas, your case is 24 CR 002117C. You're charged with theft by shoplifting and criminal trespass. Do you understand your rights?
Yes.
All right, Mr. Nixon, if you would please proceed.
Yes, Your Honor. With regard to the brief factual basis, this occurred on April 19, 2024. The theft by shoplifting, criminal trespass. The defendant was caught on camera grabbing items and walking past the point of sale. The state is recommending for count 1, 12 months, served 24 days, credit for time served 12 days, and that's from April 21st, 2024 until April 22nd, 2024. And then May 27th, 2024 until today. Balance probated, a $500 fine, anti-theft course, 40 hours community service. Stay away from the Walmart located at 844 Cleveland Avenue, East Point. As for count 2, this will be 12 months served concurrently with count 1. As for the FTA, it's added on there. There's 25 FTA 001066. The state will not process upon pleading to the underlying offense. The state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
All right, was that your understanding, Mr. Haddad, and do you so stipulate?
We do, Judge, would ask the court to consider a non-reporting probation upon completion of all conditions.
Okay. The state's position about non-reporting?
The state's going to object. I think I see even another theft by shoplifting and some probation revocations and violations.
Okay. All right. And I'm sorry, I don't have an FTA for Ms. Thomas. Is there a FTA number? There's not one
Yes.
on the calendar.
We know. I noted at 25 FTA 001.
Oh, I see it in the notes.
You
Okay.
see it?
Okay.
Okay.
Mr. Jordan, do
It's
you
on
see
that
it? One of
add-on
those-
calendar. Judge.
Oh, it's on the add-on. Okay, understood. Just wanted to make sure. Thank you so much. All right, Ms. Thomas, please raise your right hand. And do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, I do.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
Oh, Your Honor.
Did anyone force you to take a plea today?
No,
Did anyone promise you anything in exchange for taking a plea?
no, Your Honor.
And you understand by taking a guilty plea, you're giving up your right to trial by judge or by jury?
Yes,
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
yes,
And you fully understand the requirements that you have to take an anti-theft course, stay away from that Walmart on Cleveland Avenue. You're going to do 40 hours of community service. You're going to pay a fine of $500. But otherwise, the time you serve in the Fulton County Jail should close your case. Do you understand all of those requirements, Ms. Thomas?
yes, I do.
All right, as to the charge of theft by shoplifting and criminal trespass, how do you plead?
Guilty.
I accept your guilty plea. After you've completed the requirements, your probation can go non-reporting. Is there anything additional, Mr. Nixon or Mr. Haddad?
No, Judge.
All right. Best of luck to you, Ms. Thomas. That concludes your case. Who do we have next?
Position number 42, West.
All right, I have it. This is also a negotiated plea. Is that correct?
It is, Judge.
All right, Ms. West, your case is 24 CR 007746J. You're charged with simple assault, family violence, battery, family violence, and simple battery, family violence. You understand your rights? Was that a yes?
Yes, Your Honor.
Thank you. Mr. Nixon, please proceed.
Yes, Your Honor, I'll be brief. This is for the simple assault, family violence, battery, family violence, and the simple battery, family violence. That was November 13th, 2024. Officers responded. The defendant got irate and began throwing items within the mobile home at the victim. I'll get the victim's name for you. Last name Bosley, Bosley, including multiple glass items and an unknown container of substance, most likely vomit. The victim presented to officers with minor lacerations on her legs and feet, which she attributed to West's actions of throwing glass items. With regard to the battery family violence, that's the January 4th, 2025 incident. She was in a fight with her then boyfriend, Craig Wex. I'll spell that last name Weix. They were dating for 6 months, had lived together at the apartment, and the defendant jumped on his back to get a cell phone and started swinging at him in his face. For the simple assault, family violence, battery, family violence, and simple battery, family violence, state is going to recommend for count 1, 12 months to serve concurrently with count 2. For count 2, 12 months, serve 60 days, credit for time served 15 days. And that's from November 20th, 2024 to November 26th, 2024. And then May 29th, 2025 until today. Family Violence Intervention Program, 40 hours community service, no further contact with Renee Bosley. ADET, and stay away from 140 Valley Drive and no firearms. As for count 3, it'll be 12 months to serve concurrently with count 2. And again, this is a global recommendation. As for the battery family violence, the state is recommending 12 months to serve 40 days, credit for time served 11 days. And that's from January 5th, 2025 until January 13th, 2025. 40 hours community service, no further contact with Craig Wex, family violence intervention program, no firearms. The state would ask that you, the court sound for both victims in this case, when appropriate. As for the FTA, the state will not cross the FTA upon pleading to the underlying offense. And the state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
You would have an additional 15 days to serve in Fulton County Jail. Is that correct?
That is correct, Judge.
Okay, and your client wishes to move forward even with the additional time, Mr. Haddad?
I believe so, yes, Judge.
All right, and you stipulate to those 3 elements, and that was your understanding?
We do, Judge.
All right, Ms. West, please raise your right hand. Do you swear or affirm the testimony of today be the truth to the best of your knowledge and is given under the penalty of perjury? All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time? I need you to speak as loudly as you can.
No, ma'am.
Thank you. Are you satisfied with Mr. Haddad's representation?
I'm sorry.
Are you satisfied with your attorney's representation of you?
Yes, Your Honor.
All right. And you understand that you're giving up your right to trial by judge or by jury? And you understand that you're giving up your right to have the state prove these charges against you beyond a reasonable doubt? And do you fully understand the requirements of the sentence, that you're going to have to take a family violence intervention course, complete 40 hours community service, have no further contact with Renee Bosley or Craig Wex? You're going to undergo an evaluation. You need to stay away from 140 Valley Drive, and you can have absolutely no firearms. Do you understand that, Ms. West?
Yes, sir.
All right. And you further understand that taking a guilty plea may affect other aspects of your life, such as employment, probation, immigration, or other matters I may not be able to anticipate? All right. As for the charges previously listed, Ms. West, how do you plead? I accept your guilty plea. Before I do that, I am sounding now for Renee Bosley. Does Renee Bosley wish to make a statement or is on the Zoom conference? All right, I am also sounding for Craig Wex. Is Craig Wex present and wishes to make a statement?
Good.
Hearing none, is there anything additional, Mr. Nixon or Mr. Haddad?
No, Judge.
All right, best of luck to you, Ms. West. That concludes your case at this time.
Thank you, Your Honor.
All right, who do we have next?
Judge, I do have a quick announcement for position number 11.
Okay,
It's going to be Candace Florence. She actually got released.
okay, thank you. Bond it
And
out.
also, oh, I'm sorry, Judge, go ahead.
No, go ahead. I'm ready.
Also, just for Haddad, I wanted to know, Haddad, I was going to go ahead and give you a call in courtroom 2. Are you going to be available?
I am.
Okay, I'm going to call you now. Thank you.
You.
Are there any other positions we can take while Mr. Haddad is busy? Any that belong to Mr. White?
Your Honor, Mr. Bartels has one that he can handle.
Okay, yes, or Mr. Bartels. Good morning, Mr. Bartels. I didn't see you.
Good morning, Judge. Good to see you. How are you?
I'm well. How are you?
Good. I think we can do number 32, Mr. Oluwadare. Will you come up, sir? It's a negotiated plea, Your Honor.
Okay. All right. Good morning, sir. Your case is 25 CR 0028445G. You're charged with criminal trespass in this case. Do you understand your rights?
Yes.
Okay, thank you. And I believe this is Mr. Nixon. Please proceed.
Yes, Your Honor. And this is position 32, correct?
Correct, yes.
Okay. This is the criminal trespass. This was May 19, 2025. Defendant was caught at the Atlanta Marriott Marquis Hotel. And after he had already been provided criminal trespass warning, he failed to leave the property and was subsequently arrested. The state is recommending 12 months to serve 36 days, credit for time served 18 days. That's from May 19, 2025 until today. Balance suspended. Stay away from 265 Peachtree Center Avenue Northeast. Again, that's the Atlanta Marriott Marquis Hotel. The state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
You so stipulate, Mr. Bartel, is that what your understanding?
We do, Your Honor, and that's our understanding of the offer as well.
All right, Mr. Oludare, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and given under the penalty of perjury? Thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time? Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
And you understand that taking a guilty plea, you're giving up your right to trial by judge or by jury? And you're giving up your right to have the state prove this charge against you beyond a reasonable doubt?
Yes.
And you fully understand you cannot return to that location on Peachtree Center Avenue?
Yes.
All right, and you understand that taking a guilty plea can affect other aspects of your life, such as open cases, probation, employment, other things I may not be able to anticipate?
Yes.
As to the charge of criminal trespass, how do you plead? I accept your guilty plea. Is there anything additional, Mr. Nixon or Mr. Bartels?
Nothing else, Your Honor.
All right, best of luck to you, sir. Don't go back to that place. They don't want you there, okay? Take care. Have a good afternoon.
Thank you.
Good morning, Your Honor. I have someone on the calendar.
Okay, good morning, Miss McLeod. Who is your client?
It's Mr. Harris.
And what is the announcement for Mr. Harris? I just have TBA today.
Your Honor, I would like to discuss the issue of his bond.
Okay. And so what about the arraignment? Are you going to waive arraignment and
I'm
reset
going
him?
to, yes, Your Honor, I'm going to waive arraignment. But I would also like to see if the court is inclined to modify his bond.
Okay. Oh, I have a feeling you're going to ask me for a signature, Brown. We'll see.
Yes,
All
Your
right,
Honor.
I don't typically do that on a revolver, but let's hear. All right, Mr. Harris, your case is 25 CR 002913Y. You're charged with possession of a pistol or a revolver by someone under 18. Do you understand your rights this morning?
Yes, ma'am.
Thank you. Ms. Washington, may I please have Mr. Harris's history, position 15?
Yes, Your Honor, there are 3 adult arrest cycles. I'm sorry, 2 adult arrest cycles, which would include this case and an FTA. Nothing further.
Okay, thank you. Ms. Falk?
Yes, Your Honor. Just to let the court know this, the defendant is also currently on no bond status on 25 PI 004170. That is for 2 counts of aggravated assault, 2 counts of cruelty to children, and he also has a failure to appear that he is on no bond status. That is 24 SC 005811. So that is in addition to, he's currently being held on those charges, in addition to the current charge he's being held on in our office. And that 24 SC case is a armed robbery, possession of a firearm during commission of a felony, willful obstruction of an officer, and possession of pistol by a person under 18 years of age. In our case, this incident happened on May 22nd of 2025. Officers had eyes on a wanted person who is the defendant. He was wanted for charges that he was arrested for he's now in custody for. They did a takedown of him, and when they had him in custody, they checked him for weapons, asked him if he had one on his person. He stated that he did. It was in his waistband. They lifted his shirt, checked his waistband, and recovered a black and silver Smith & Wesson 9mm handgun. He also stated he believed the gun was stolen but did not care. And so they took him into custody and then charged him accordingly. The defendant, just to add on to this, had a current bond in his 24 SC 005811 case. So he did have a bond order on that case that was issued, it looks like October 8th of 2024. That was a $25,000 bond. And it was As part of that, defendant shall be released and with supervision. He is to have wraparound services, no drugs without a legal prescription, no alcohol. Defendant is court ordered to be in a virtual education program, must continue with all Ascend programs and no social media, as well as I believe there was a provision of no firearms. Let me just double check. So the concern for the state on this one is that the defendant was carrying a firearm after having been released on a case that involved a firearm and is now also in custody for cases involving a firearm. I think you can see where this is going. The defendant was given a $2,000 surety bond by Judge Mincy on May 23rd, 2025. Frankly, I think that is very kind of her, considering his current charges, previous charges, and what he's currently being held on. And so given that we do believe he is a risk of reoffense, a risk of not coming to court since he has an FTA, I think basically every IALA factor on the board has been violated. I would ask that the bond remain as set.
All right, thank you. Ms. McLeod?
Yes, Your Honor. My client is 18 years old, Your Honor. He definitely is not in a position to pay for any kind of bond. That is why he's sitting in jail. I just do not think it's a good idea for an 18-year-old to be sitting in jail around much older people. I just think it's bad for him. And of course, if he doesn't get some kind of signature bond, he's just going to sit there. The state's offer, even if he were inclined to take a plea, requires him to sit there, I believe, for at least another 3 months or so. It's a significant period of time that they're asking him to spend in custody, Your Honor. I also believe that if he's out, he will be better able to defend against the state's charges. Him sitting in jail, he'll not be able to help me to really sort through the evidence, because I do not believe everything that is in the warrant is accurate based on my understanding and my discussion with his mother, Your Honor. Nothing further.
All right, and he is sitting on a no bond, correct?
Not for this case, Your
Not for
Honor.
this case, but for something else. All right.
Yes.
I appreciate your advocacy, Mr. McLeod, and I do appreciate your position. However, bond will remain at set with the current conditions. All right, Mr. Harris, best of luck to you. That concludes the matter for this time. Ms. McLeod, do you have any additional cases on this calendar today? I'm sorry, Ms. McLeod, you went out.
Not on this one, Your Honor, but I do have something on the competency calendar, so I would like to be excused to log on back for that.
All right, we'll see you back at 11 o'clock. Take care, Ms. McLeod. Thank you.
Thank you, Your Honor.
All right. All right, who do we have next?
Position 20 and 21, Kimbrough.
All right, Mr. Kimbrough, your case is 20 CR 006088Y. You're charged with criminal trespass and simple battery in this case. You also have an FTA. What is the announcement for this case, Mr. Haddad?
That's my case.
I'm sorry,
Judge.
Mr. White. What's your announcement?
We're asking, we're doing a bond hearing, Judge.
Okay. All right. Ms. Washington, can I have the history for this defendant, please?
This is Mr. Kimbrough, correct?
Correct. Position 20.
There are 9 arrest cycles. There was an arrest in December of last year for possession of marijuana less than an ounce, possession of meth, trafficking, controlled substance, and other felonies. And no disposition is listed. That's out of Wilcox County. There was an arrest in 2019 for possession of drug-related objects. No disposition was listed. There was also an arrest in 2019 for battery and criminal trespass. No disposition was listed on that. There was
This case.
I'm sorry.
I believe that might be this case.
Okay, I don't. There was a 2014. There was a 2014 arrest for possession of a Schedule 1 or 2 controlled substance, purchase, possession, or sale of marijuana, and also a probation violation. No disposition is listed. There was a 2009 misdemeanor conviction for possession of marijuana less than an ounce. Nothing further.
Right, thank you, Ms. Falk.
Yes, Your Honor. The defendant is currently being held on a $3,500 cash bond that is based on multiple failures to appear. The defendant has a failure to appear from July 7th of 2021, a failure to appear from December 13th of 2022. And there were multiple notices that were returned to sender that were issued, one in June 30th of 2021, one November 18th of 2022, and one on December 13th of 2022. That's due to a plea arraignment in 2021, a plea arraignment in 2022, and a plea arraignment the following month in 2022. And so the defendant has one bench warrant, but it is multiple times where he was noticed to appear and failed to appear. And that's why that bench warrant was issued and the defendant was finally arrested. As you've heard, the defendant has had cases subsequent, I believe, to this one, which is of some concern. Notice was sent, but the notice kept being returned to sender. And so the state asked that the bond remain as set on this case. That's all for the state.
So currently on the FTA, is that where the $3,500 is pending?
That is correct. And subsequent to our case, he picked up, it looks like he's had 3 more cases subsequent to our case.
I don't think that's true. I think I heard one case, and I think one of the cases would be this FTA. So I don't believe it's maybe one.
Okay, so the FTA is on position 21, and he still would have to make bond. What's the bond on position 20?
Right. It's on the FTA. There is no additional.
Okay, I got you. Understood.
It's just the FTA. And Your Honor, he has an arrest in December of 2019, which was after this case, for possession and use of drug-related objects, a case in Wilcox County in December of 2024 for possession of meth, possession of marijuana, and crossing guard lines, as well as use of communication device in furtherance of a felony. And then a May 27, 2025 case where he got arrested for marijuana less than an ounce. So as I stated, there were 3 subsequent arrests subsequent to our case.
Well,
go ahead, Mr. White.
Your Honor, first of all, so this case is from 2019. He did come to court from the day that they issued the 12/17/2020, the court date that he supposedly missed, that is the basis of the warrant. He went to court and was turned away by the clerk because of the pandemic, is what he was told. And I'm not sure if Your Honor remembers at that time, you know, we'd schedule things that looked like it'd be getting better, and then there'd be some sort of surge, and then so they would close courts. Beyond that, all of the other notices were returned. He never received them per the state. They said they were returned to sender, so he did not get them. I'm not sure what the issues were, but considering the age of the case, the fact that he didn't receive notice because they were returned, and the fact that on this date that he supposedly the warrant for not appearing shows up, he did go to court and was told to leave. He's been working for 10 years at the same job, Auto Spa Bistro, and you know, we're just asking him to be allowed to sign his own bond and come back to court. The age of the case, plus there were some issues whether or not he came to court or not. Additionally, all of those other arrests, I think I heard one conviction, and that was 2009. The rest of them were just arrests.
Okay, so Mr. Jordan, let me ask you a question. If I am going to convert his bond, how does the order need to read? I did this wrong last time, is the reason I'm asking. If I make any change at all, it needs to be on the FTA only?
So you're amending, so he has a 3,500 cash bond hold on the FTA. As long as you can put the case number on there, but the FTA case number needs to be on there as
It needs to
well.
be on there. Well, okay. Last time I did it wrong. Okay. I'm in a benevolent mood today. I'm gonna let Mr. Kimbrough sign his own bond. It'll become a $3,500 signature bond. Mr. Kimbrough, you are getting a second chance. Please keep your address current with the court. You will not get a second chance at grace here. Make sure you call the court monthly and check on this matter. Do not get another FTA. Make sure you show up, resolve this, and stay in touch with your attorney, okay?
And Your Honor, I do just want to object due to the statute. He has an FTA. He is not qualified for a signature bond through the jail. He is qualified for a signature bond through pretrial services.
I don't think that's correct, Ms. Falk. Let me look. An FTA does not equal that it can't go through the jail. I don't think that's one of the bond restricted offenses. I've got those
It is
burned
one of the
into
bail
my.
restricted offenses, Your Honor.
Let's read.
I can pull up the code.
I'm pulling it up as well. I got those burned into my head. And usually it depends on the type of underlying charge, Ms. Falk. So that's why I think it's an FTA as it pertains to, let's look, hold on. Mr. White, you were going to say something?
Also, this is a question. Does it apply to cases this old before that went into effect? This is a 20.
Yeah, it does. We don't get around it for that. I got that part. Out of an abundance of caution, let me read. We don't have a whole lot of time. I will send it through pretrial services at level 1. Okay.
Your Honor, what's the bond amount?
It's $3,500 signature bond at level 1 through pretrial services per judge. That way, at least he's being forced to check in. All right.
All right.
All right, Ms. Falk. If you want to lodge any further objections, I'm happy to hear those.
None, Your Honor.
All right. Take care. Anything additional, Mr. White?
No, Judge. Thank you.
Mr. Kimbrough, don't do any more. Make sure you check in at pretrial. All right.
Thank you.
All right. Who do we have next?
Next is Lewis, position number 22.
We'll go after them, Judge.
Okay. So we're gonna do 22 first. Let's do the position 22. Mr. Lewis, your case is 25 CR 002909G. You are charged with criminal trespass. You understand your rights?
Yes.
All right. That's a yes? Okay. Thank you. The announcement I have is that this is a negotiated plea.
That's correct, Judge.
All right. Let me look at one thing. Ms. Falk, please proceed while I'm looking.
Yes, Your Honor. This case, the recommendation is 12 months served, 30 days, credit for time served, 15 days. That is going to be from May 22nd, 2025 until today. Balance probated, MHET, stay away from Wildwood Park townhouses located at 405 Fairburn Road Southwest in Atlanta, 40 hours of community service. This incident happened back on May 22nd of 2025. Defendant had a prior criminal trespass from that location on May 15th, 2025, and returned and remained at that location after being given that trespass order. And that's what led to him being arrested. That's all for the state. And we do ask the defense to...
Very briefly, can I be placed in a breakout, please, with Ms. Falk and Mr. White? Very briefly.
Yes, ma'am. You, Ms. Falk, and Mr. White, correct?
Yes, correct. Mr. White, was that your understanding of the offer, and do you so stipulate to the three elements in this case?
Yes, yes, Your Honor, we do.
All right, Mr. Lewis, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
And you understand by taking a guilty plea, you're giving up your right to trial by judge or by jury?
Yes.
And you understand that you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you further understand you absolutely cannot go back to that address. You're going to complete 40 hours of community service and you're going to undergo some evaluations. Do you understand that?
Yes.
And you understand that taking a guilty plea may affect other aspects of your life, such as probation, employment, immigration, or other matters I may not be able to anticipate?
Yes, I do understand.
All right. As to the charge of criminal trespass, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense?
Your Honor, we would just ask that the probation go non-reporting upon completion of all of his requirements.
Any objection to non-reporting, Ms. Falk? All right, it can go non-reporting once he's completed the requirements.
Thank you, Judge.
Best of luck to you, sir. Who do we have next?
All right, thank you.
Petition number 34, Rouse.
All right, and the announcement, Mr. Haddad, from Ms. Rouse?
Your Honor, that is gonna be a plea, for Ms. Falk. Ms. Rouse opted for the 120-day, house arrest.
Okay. So, I'm sorry, it was a negotiated plea?
It is, Judge. I apologize. We had negotiations in the background, Judge.
Okay. All right.
In your honor, Mr. Nixon will be handling this plea. I was just entering into negotiations with PD Haddad, but he is aware of the options that Ms. Rouse was given and is prepared to move forward.
Thank you. I appreciate that. Ms. Rouse, your case is 25 CR 001489B. You're charged with theft by shoplifting. Do you understand your rights this morning? Is that a yes? Please say it as loudly as you can. All right. Thank you. Thank you. Mr. Nixon, please proceed.
Yes, Your Honor. This occurred on March 7th, 2025. This again was a theft by shoplifting. The officers was advised the defendant did shoplift a laundry detergent washing powder from the location 3310 Dogwood Drive, and that's in Hapeville. The state is going to recommend the 120 days house arrest, anti-theft course, $500 fine, 40 hours community service, a stay away from 3310 Dogwood Drive in Hapeville, and that's the Family Dollar located at that address. With regard to the FTA, this might possibly be the add-on. That's 25 FTA 001068. The state will not prosecute upon pleading to the underlying offense. And the state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
You so stipulate, Mr. Haddad?
We stipulate, Judge.
And that was your understanding of the offer?
It is, Judge, yes.
All right. Ms. Rouse, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
And you understand that by taking a guilty plea, you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand the requirements, including the fact that you're going to be on house arrest for 120 days. You're going to complete an anti-theft course, complete community service, stay away from the Family Dollar, in Hapeville. And you're also going to pay a fine. You understand all of that, Ms. Rouse?
Is there any way my fine can be converted into community service hours?
Do you need to speak to your attorney? Was that something that you had discussed with him?
Judge, I would ask the court to change it, and I apologize, I did not specifically ask Ms. Rouse. but apparently she wants to convert it to a community service judge.
Please, if possible.
I'll consider it, but I'm not sure that that's what I'm gonna do. Mr. Nixon, what's the state, I know that, I'm just let the state weigh in. I know that's up to me. Does the state have a position about converting that fine?
Per the convictions, I think I've noted a 2009 theft by shoplifting and a 2016 theft by shoplifting, both convictions. So the state was recommending the $500 fine per the statute.
Okay. All right, I'm gonna convert it to community service, so you'd have to do 90 hours of community service, Ms. Ross. Do you wish to move forward with the plea?
Yes, ma'am.
You further understand you cannot go back to that Family Dollar?
Yes, ma'am.
All right, and you understand that taking a guilty plea may affect other aspects of your life, such as probation, employment, immigration, other matters we may not be able to anticipate?
Yes, ma'am.
All right, as to the charge of theft by shoplifting, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state of defense?
No, Judge, thank you.
All right, best of luck to you, Ms. Ross. That concludes your case. What do we have
So-
next?
Number
So-
8.
Yes, I'm sorry, Mr. Jordan.
So this sentence is just to read 12 month, I'm sorry, 120 days on house arrest?
Yes.
Okay. Thank you.
That's my understanding. That's correct, Mr. Nixon and Mr. Haddad?
Yeah, Judge.
Okay.
But she's gonna complete all the conditions while she's on house arrest, or
That
she?
was my understanding. Is that correct? Mr. Nixon, Mr. Haddad?
Judge, I believe she'll have time afterwards to complete that.
So she still needs to be on probation for 12 months then, correct?
Yes, Judge.
Okay.
Okay, thank you.
All right, who do we have next?
Number 18, Houston.
All right, Mr. Houston, your case is 25 CR 002098B. You're charged with criminal trespass. You understand your rights?
Yes.
All right, I have that this is a negotiated plea. Is that still correct?
Yes, Your Honor.
All right, Ms. Falk, please proceed.
Yes, Your Honor. The state's recommendation on this case is 12 months, serve 30 days, credit for time served 15 days. That will be from May 22nd, 2025 until today. As conditions of this plea, the defendant is balance suspended and he is to stay away from First Presbyterian Church that is located at 1328 Peachtree Street in Atlanta. The facts of this case, just very briefly, are that the defendant went to that location on May 22nd of 2025. The officer was working an extra job there. He had been criminally trespassed the day previous on May 21st, 2025 for unruly behavior. And so he had been given that warning. So when he came back onto the property, the officer took him into custody. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Can you still stipulate, Mr. White?
We do, Judge.
And that was your understanding?
Absolutely, nothing further.
All right, thank you. Mr. Houston, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury? Is that a yes?
Yes.
Thank you. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a guilty plea today?
No.
Did anyone promise you anything in exchange for taking a guilty plea?
No.
And you understand that by taking a guilty plea, you're giving up your right to trial by judge or by jury?
Yes.
And you're giving up your right to have the state prove this charge against you beyond a reasonable doubt?
Yes.
And you understand that you cannot go back to that church, but otherwise you should not have to serve any additional time in the Fulton County Jail?
Yes.
As to the charge of criminal trespass, how do you plead, Mr. Houston?
Guilty.
I accept your guilty plea. Is there anything additional, Ms. Falk or Mr. White?
No, Your Honor.
Best of luck to you, Mr. Houston. That concludes your case. Don't go back to that church. All right, who do we have next?
This is petition number 35 and 36, Mr. Melvin Client.
Hmm. 35 and 36?
Yes, Joseph Smith.
Okay, and I saw that he has a private attorney.
Yes, he's logged on.
I'm on the call, Judge.
Okay, I see. What is the announcement for this case
This
today?
will be a plea.
Okay, we're taking a negotiated plea. All right, Mr. Smith, your case is 23 CR 0068005J. You're charged with obstruction in this case. You also have an FTA. Do you understand your rights today?
Yes, ma'am.
All right, thank you so much. Mr. Nixon, please proceed.
Yes, Your Honor. This occurred April 11th, 2023. Officers conducted a traffic stop on a black Honda Accord, speeding 116 miles an hour. While conducting the traffic stop, they learned that the passenger, Mr. Smith, had an active warrant. And when the officer attempted to detain Mr. Smith, he ran across all lanes of I-20. This would be a time served, 46 days credit for time served, 23 days. That's from October 30th to November 1st of 2023 and May 17th, 2025 until today. With regard to the FTA, the state will not process the FTA upon appealing to the underlying offense, and the state would ask that the defense stipulate to venue, factual basis, and identification for the purpose of this plea.
We stipulate.
Thank you, Mr. Melnick. Mr. Smith, please raise your right hand. Do you swear or affirm testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
You understand that taking a guilty plea, you're giving up your right to trial by judge or by jury,
Yes, ma'am.
and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt,
Yes, ma'am.
and you're satisfied with your attorney's representation,
Yes, ma'am.
and you understand that taking a guilty plea can affect other aspects of your life, such as probation, employment, immigration, other things your attorney and I may not be able to anticipate.
Yes, ma'am.
As to the charge of obstruction, how do you plead, Mr. Smith?
Yes.
I accept your guilty plea. The time you served in the Fulton County Jail should close your case. All right?
Thank you.
Take care. Don't do that
Thank you, Judge.
anymore. All right. Does that conclude your business, Mr. Melnick?
Yes, Your Honor. Thank you. May I be excused?
Take care. Have a
Thank you.
wonderful afternoon. Bye-bye.
Thank you, you too.
All right. Who do we have next?
Number 14, Griffin.
I have, this is a negotiated plea. Is that correct?
Yes, Your Honor.
All right. Thank you, Mr. Griffin. Your case is 25 CR 002194J. You're charged with simple assault and simple battery. You understand your rights? Is that a yes? I just need you to speak loudly so that we can hear you, okay?
Yes, I do.
All right, thank you so much. Whose case is this for the state? Is it Ms. Falk?
Fine, Your Honor. I didn't realize my video was off. I apologize.
That's all right. Please proceed.
Yes, Your Honor. There are 2 counts in this case, simple assault and simple battery. On the simple assault charge, the state's recommendation is going to be 12 months concurrent with count 2. On count 2, 12 months served, 60 days, credit for time served, 15 days from May 22nd, 2025 until today, balance probated, 12 weeks of anger management, no further contact with Deldon Fain II, stay away from 508 Main Street in Atlanta. The incident that happened here was on May 22nd, 2025 at 508 Main Street Northeast. The defendant was identified by Deldon Fain II. He stated that the male assaulted him. They believed he was squatting in a vacant apartment that kept getting broken into. Mr. Fain asked the defendant to leave the property while they were both outside. Mr. Griffin threw a rock that he had in his hand at Mr. Fain. And then Mr. Griffin, the defendant, punched Mr. Fain in the face, which then caused the altercation to ensue. The defendant was arrested as a result of this. We have spoken to Mr. Fain, and he does agree with this recommendation. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. We would like to sound from Mr. Deldon Fain at this time, if he is here and would like to speak. That's all for the state.
Do you so stipulate, Mr. White, and what's that your understanding?
Yes, Your Honor.
All right. And is Mr. Fain present on the Zoom conference and wishes to make a statement? Okay, hearing none. Mr. Griffin, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the Mr. Griffin? Please raise your right hand. Thank you. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yeah.
All right. Thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
Nope, not at this time.
Did anyone force you to take a guilty plea today?
Never agreed to take a guilty plea.
Do you want to take a plea today?
No, I'm not trying to take a plea today.
You do not want to take a plea.
Nope, I'm waiting to see Judge Cross for my probation.
Okay, so it sounds like your client doesn't want to take this plea today, Mr. White.
Judge, that was a suggestion yesterday, but
Okay, so do we want to reset further notice for trial?
yeah, I'll enter over.
I'm sorry, I can't hear your attorney, Mr. Griffin. Please, Mr. White, what were you saying?
I'll submit a waiver, Judge.
All right, we'll reset this case for trial. Mr. Griffin, your attorneys have some more work to do. They'll speak with you. The case will be reset and additional matters will take place between now and then. All right, best of luck to you. All right, who do we have next? Oh, are we done?
Yeah, he's on the list.
Judge, I think that's.
Let's check, hold on. What about position 3, Marcus Bell?
It's gonna be a not guilty, Judge.
Not guilty, okay. I have announcements for those. What about position 8 and 9, Dillard?
It's going to be a waiver, Judge.
Okay. These calendars are getting shorter and shorter. All right, position. We can review the calendar in a moment. What about 17? Is that a waiver, Hillard?
No, Judge. Actually, I came to see him at the jail yesterday. They sent me up to a floor. I was told he wasn't there anymore. And then this morning they say he's in Cobb County, but I guess they didn't bring any Cobb County people down. So I guess we just need to reset him.
Reset 1 week?
Give me 1 second. Let's see.
It's a time served. No, it's not one. It's not time served. So 1 week will not
1 week.
prejudice him.
That's correct.
Reset SAP 1 week. Okay, what about position 31 where the request was for a bond hearing?
Honor, that was we worked it out. I submitted the proposed order to Mr. Jordan.
Okay, a proposed bond order or a proposed what order?
So set aside the bench warrant, reinstate his original.
Okay, understood. That works for me. All right. Could we really be done? Oh, position 33, Richardson.
Your Honor, Mr. Richardson is also in Cobb. He was taken to Cobb yesterday, the day before, and they've not been out, so reset for next week. Judge.
And he will not be prejudiced by a 1 week reset 1 week. And I think that's all purpose.
Actually, Your Honor, Mr. Richardson, position 33 is prejudiced by the reset.
I apologize.
Wasn't it credit for, he's only been in 21 days. The state was asking for 60 days.
Oh, no, the state modified that to 42 days.
Oh, the state did ask for that.
Mm-hmm.
Judge, in fairness too, he won't overall be prejudiced because he's got a felony hold anyway for now.
Okay. 1 week reset.
1 week would be fine, Judge.
Okay. Understood. Thank you, Mr. Haddad, for that point of clarification. Yeah, I have announcements for everything. Oh, what about our add-on position 2, Mr. Henderson?
There's a add-on?
Yeah, Brandon Henderson on the add-on calendar.
I wasn't aware either.
That is part of Mr. Henderson's case.
Oh, we did Mr. Henderson not guilty, number 16.
Yeah, I did the add-on.
All right, so not guilty, reset for the notice.
Judge, for clarification, position number 45, Denard Wilson actually bonded out, made bonds.
Okay. Release.
19.
Okay, I don't see any positions without announcements. Mr. Jordan, at your convenience, will you please review the calendar for us?
Position 1 was a plea. Position 2 is a not guilty plea, waived jury. Position 3 is a not guilty plea, waived jury. Position 4 is a DA transfer. Ms. Falk. You're still muted.
Your Honor, that case was accepted by the DA's office and we will be submitting the order for your signature today.
Thank you.
Position 5 is a DA transfer.
Let me see. I believe Mr. Adams accepted that as well. I just want to double check, but we will believe that was accepted as well, and we will be submitting an order for transfer. Yes, they did accept the transfer of that case as well.
Position 6 was a non-negotiated plea. Position 7 is a DA transfer.
Position 7, Quintarius Davis, was accepted as by the DA's office. We will be submitting the order today.
Position 8 is a not guilty plea, reset jail jury, same as 9, we reset jail jury. Position 10 is a not guilty plea, reset jail jury. Position 11 was released. Position 10 is a DA, I'm sorry, position 12 is a DA transfer.
The DA's office did accept that transfer, and we will be submitting the order today.
Oh, it was the same for 13 as well, same defendant.
I believe 13 is staying in state court.
That is correct.
And we're waiving.
Okay, thank you. So 13 is reset jail jury. Position 14. Position 14 is a not guilty plea, waived jury, jail jury. Position 15 is not guilty, waived jury. Motion to modify bond was denied. Position 16 is a not guilty plea, waived jury. Position 17 is reset to the 6/12/25 SAP calendar. Position 18 and 19 were pleas. Position 20 made bond, reset further notice.
Mr. Jordan, that was the one that was converted to a signature bond. And I know the judge asked you a question about bond. Do you need a bond order from me?
I'm sorry. You're right. What,
is it coming from the judge or do you need a bond order from me?
Oh, one from you.
Okay.
Send the bond order, please. Thank you.
So the amended bond was on, let's see.
And PD White, just so I have my notification correct, are you filing a waiver of arraignment on this?
Yes.
Okay.
Position 21 was an amended bond of $3,500 sign-on bond, pretrial level 1 per judge. Position 22 was a plea. Position 23 was a not guilty plea, waived jury. Position 23 and 24, reset jail jury. Position 25 was a not guilty plea, reset jail jury. Position 26 is the same as 27 and 28 was released. Position 29 was a plea. Position 30 was a plea. Position 31 is reset to the 6/12/25 SAP calendar. Position 32 was a plea. Position 33 was reset to the 6/12/25 SAP calendar. Position 34 was a plea. Position 35 was a plea. Position 36 was null pros. Position 37 was a plea. Position 38 was null pros. Position 39 is reset to the 6/12/25 SAP calendar. Position 40 was a plea. Position 41 was reset to the 6/12/25 SAP calendar. Position 42 was a plea with the add-on case 25 CR 00123J was a plea. Position 43 was null pros. Position 44 was a plea. Position 45 was released, reset further notice. And the add-on calendar was mostly the FTA cases. So 1 was waived jury with bail. 2 was Brandon Henderson, reset further notice. Position 3 was a plea with Jordan, which is null pros. Position 4 was null pros with the plea for Rouse. And position 4, yeah, Rouse. Position 5 was Thomas, was null pros with the plea. And that was it for the add-on calendar.
Okay. Any comments, changes, or corrections?
No, Judge, may I be excused?
Yes, you may. Those who don't need to remain with us for the DV. Oh, wait, Mr. Haddad, before you go, you don't represent the person on the DV bench warrant? No, that's Ms. Bader, so you're free to go. Anyone who does not need to remain with us for the 11 o'clock calendars is free to go at this time. Ms. Bader, is your client already on? Do you know?
Yes, Your Honor.
All right, we're going to go ahead and do the DV bench warrant calendar. Again, anyone who does not need to remain with us for the bench warrant calendar or the 11 o'clock special competency is free to go at this time. I'm calling the case of 24 CR 002156C in which Mohamedou Sadi is charged with simple battery family violence. And you said your client is on Zoom?
Yes, there he is with his mother, Judge.
All right.
And Your Honor, I mean, I would prefer to be in a breakout session. There's some MH considerations here. Although if you're okay with me being a little bit vague in this case, I also was looking on the booking information. It doesn't look like he has an active warrant for this particular case. He did. I was told by my litigation manager once I was appointed on this case to come to the clerk's office and get him on this calendar. But as I'm looking now, I don't see that he has an active bench warrant. I just wanted to put that out there and make sure that
You see an active bench warrant for a different case, Ms. Bader?
I do not.
Mr. Jordan, do you see an active bench warrant? Does anyone see one, Mr. Nixon? Because if not, this calendar does not.
I didn't realize I was muted. But he doesn't have an active warrant on this case. I don't think the litigation manager ever issued the warrant, but he has an active EW warrant, willful obstruction. It was issued on 2/23/25.
That wouldn't be on the DV bench warrant calendar, then that should go
No,
somewhere.
I think they didn't look at the warrant to see what the warrant was. So this warrant was never issued by the litigation manager for that judge.
Okay.
Your Honor, I am showing one on the GCRC I just ran for an FTA with APD from December 2nd of 2024. So
That's the obstruction case?
I'm
No,
not
that would've-
sure. There is a Sandy Springs hold for obstruction. and that warrant date is February 23rd of this year. But there's an APD hold showing on the GCIC for the
What
FTA.
What year is
From-
the APD hold from?
From December 2nd of 2024, and then one from Sandy Springs for a obstruction case.
The December
from
2nd,
February.
sorry, the December 2nd, 2024 date does line up with this particular case, so we could always have the hearing and I can submit an order just to be safe.
Right,
If
it does.
That's what.
It
Your Honor
does say
decides.
24005959 FTA.
But apparently the clerk never actually put in the warrant, so he wouldn't even be able to really surrender himself on this particular case if you see what I mean?
Right, but the problem is I mean, if he gets picked up, he he will get picked up on something. I'm not
But
sure
it
why
won't
they-
be this, it won't be this case though,
Right.
because that's the problem. Even if I said he has to go surrender himself on this case, there's nothing for him to surrender to. It'd be that other case that I have no control, authority, or anything I can do with this one.
Right, I understand.
Okay, so I think in light of that, we're gonna have to set aside. I don't even think I can set it aside because there's no bench warrant to set aside.
Nothing to set aside.
Right, I can't set it aside.
So Judge,
Yep.
looking at the notes, under the warrant itself, as Ms. Bradar said, it was set aside as MHE, reset for MHE is what it says on the case. So it was set aside by the division judge.
Okay. So what do we do now, Mr. Jordan?
We don't have to set aside the warrant. It was already set aside by the division.
Okay, so there's nothing really
May
to
the
do here.
21st.
But just to advise the defendant, he does still have an active warrant, just not
for this
with-
case.
on this case. And so if he is pulled over, he would be arrested on the active Sandy Springs warrant.
Right, but
And
not.
is there any
Go ahead, Ms. Bitter.
is there any way we could get, I'm not sure if we're on the record right now. Is this on the record or?
It is.
It's been
Okay.
recorded. Mhm.
Because I would like to just address that or like ask the ASG about that, because we've made a lot of progress since I've been appointed on this case with the social workers in my office. There is a lot of MH in this particular situation, and
You want
Ms.
the case
Bader,
referred? Where do you
right.
want the case
I don't
referred?
want to undo all that work. So I'm trying to figure out if there's a way to if there's a round trip order, or I'm not sure what, or if
Ms.
this
Bader, if you could do me a favor, I don't mean to interrupt. I don't think this is the most appropriate place to get into this discussion, and I cannot see the warrant. So how about this? Why don't you send me an email, and I can look into the warrant, pull the warrant, and see if I can address it.
Okay.
Okay, so to Mr. Sadi, you've heard the information today. There's nothing I can do. The warrant that you have is not in the case that's properly before me. You'll probably need to communicate with your attorney further about how to resolve that warrant. The case that you had regarding battery family violence that bench warrant has already been set aside. Okay, so you're free to go at this time, but just know that there is another active warrant against you, and you probably need to continue to work with Ms. Bader to address that one. Okay?
And I'll give you a call. I'll give you a call right now, okay?
All right, Ms.
thank
Bader,
you,
take
Ms.
care.
Butler.
Have a good afternoon.
Thank you, Judge Williams.
Okay, bye-bye. Have a good day.
You
Is
too.
Mr. Bartels there? Can we do the other 11 o'clock? I would love to let you all go well before lunch. Doesn't look like it. Oh, there's Mr. Bartels.
And Mr. Nixon, ASG Nixon, you are excused.
Yes,
With
anyone?
the court's permission, I apologize.
Yes. No, I'd already excused him. Anyone who does not need to be here for our 11 o'clocks are free to leave.
Yeah, the courtroom is clear right now except for Mr. Pullins.
All right, so do you want to do Mr. Pullins first?
Well, I had, you can have a seat, Mr. Pullins. This will be a plea, Your Honor. It's a trespass case. I think we know what the offer is going to be, but I haven't confirmed that with Ms. Falk yet.
Okay, Mr. Pullins, your case is 23 CR 002846C. You're charged with criminal trespass. Do you fully understand your rights today?
Yes, ma'am.
All right, Ms. Falk, what is the offer?
I didn't know there was a request for an offer on this one.
Okay, do you need a moment?
The one there was a request on, I sent the offer.
Okay.
I did send an email with her, also Ms. Gilliard. I asked about an offer. I did get the offer on Ms. Dunford.
Oh, you sent it this morning about 20 minutes ago. Okay.
Well, I did send the one from Ms. Gilliard yesterday, so.
Miss Gilliard is gonna be a plea as well?
That's correct. Yeah, she was reevaluated and found competent.
All right, so, what other positions are we taking, please, on Mr. Bartels?
Well, just to clarify, it'll be, let's see, Ms. Dunford, which is number 4, and number 5 is her FTA. Ms. Gilliard, has 2 cases, number 6 and 7. And, this is Mr. Pullins, who is number 9.
Okay.
I mean, we can come to Mr. Pullins and Ms. Gilliard, towards the end of the calendar, if y'all want.
Okay, Ms. Falk needs a moment, I think, to take a
Just
look.
5 minutes, I can knock it out. But yes, I
All right,
can't.
so we need, that's fine. Let's put, let's see, we're gonna have to still go into a breakout for this since are we gonna talk about the other cases or let's give Ms. Falk 5 minutes. Let's take a 5-minute break. We're way ahead of schedule and then we'll come right back. All right? Thank you.
Thank you, Your Honor.
I'm gonna go get a city.
Okay, thank
You said 4 South Street.
Oh. But she said she got. Well, since she got the street, and she just refused to. You don't have a court on, I think a lot of these cases. Says, well, I don't know where we're used to do something. And I'm probably gonna say. It's ridiculous that because the system. It's like, oh, well, the system doesn't have to run back. Why can't we fix the system? That's broken down. Yeah, exactly. Well, sometimes. If they don't have enough staff, or if they don't want to be the person, they'll say what he's. Excuse me, Mr. Cole, I got a need us here.
Are we ready to continue?
There was a little bit more to go into in detail with pull-ins, and so I'm about to send the offer now, and I'm also CCing Your Honor and Mr. Jordan, so everyone has the offer on the 3 MH cases.
Okay.
Okay, I'll check my email and get those.
Okay.
All right. Can we still probably need to go into a breakout, even though well, if we're gonna discuss any aspects of it.
Do we have a court reporter for any of these?
I don't think do we have one, Mr. Jordan?
Yes, we do, Judge.
Okay. Thank you, Ms. Grace.
Okay, thank you. I just wanted to make sure they were here because I know that sometimes they get excused before we can handle them. All right, so Mr. Bartels does have the email as well as Your Honor and Mr. Jordan.
Okay.
Okay, I got it. I'll check it now. Yeah, Ms. Falk, it looks like I got the offer on the first case for Ms. Gilliard, number 6. Is the offer basically the same for number 7?
My apologies, I thought number 7 was a FTA. I'm sure it will be, but just let me look really quickly.
Bedford is the one who has the FTA.
I apologize. Let me see.
How long has Mr. Pullins been in?
He's been in for, I believe I put his date of incarceration.
look.
He's been in for 18 days.
Okay.
But there is, if you can see with the asterisk, he has 2 cases where he's currently on probation for the same offense at the same location. Okay, so, okay. It looks like she entered a plea of guilty on her theft by taking and criminal trespass case.
On 485?
The disposition, hold on. Let me see.
Because it looks like both of those are showing on her booking screen.
Let me just make sure. Okay. So she has 1485.
Right.
Okay. No, there was another one that looked surprisingly similar.
And I think that may be a typo, but on count 1 and 2, she served the same number of days, right? 79 days.
Yes, she has. And I'm sending you the offer. And yes, it's substantially similar.
All right, Mr. Bartels, we'll give you some moments to look over it and give us your announcement.
Okay, very well, Judge.
All right, it is 11 o'clock. We'll start the competency calendar if Mr. Bartels is ready to move forward.
I believe we are ready, Judge.
Before, I'm sorry, go ahead. Are we gonna still take that plea?
Well, we've talked to Mr. Collins at greater length, Your Honor. Ms. Burgess and I both have real concerns about his competency.
Oh, let's put us all in the breakout. Hold on, since we're gonna say things like that. Can I be putting a breakout? Ms. McLeod can come courtroom 2. Myself, of course. And is there anybody else on Zoom that needs to come in that's not in the courtroom? Oh, yes. Ms. Falk, of course.
Yes, ma'am.
Ms. Falk.
We're gonna take the pleas, okay, in position for position. Who do we have at ACDC?
Ms. Dunford,
Okay, Ms. Dunford, your case is 24 CR 007720B. You're charged with theft by shoplifting. Do you understand that you have the right to remain silent? You have a right to an attorney, and we're moving forward today as if you wish to take a plea. Is that what you'd like to do, Ms. Dunford? I can't hear you. Speak as loudly as you can.
Yeah,
I'm sorry. Do you want to take a plea today? Is that a yes?
he's not guilty.
You plead not guilty? You wish to go to trial? Okay, I don't think we can take this plea today, Mr. Bartels.
can we reset that for 1 week, Your Honor?
Yes, we'll reset 1 week.
We'll
Okay.
revisit.
Yeah, I understand completely. Ms. Dunford, your attorney's gonna speak to you further and we're gonna address your case next week, okay? All right, take care. Have a good afternoon. Can we have Ms. Gilliard, please? Ms. Gilliard, your case is 25 CR 001464Y, in which you're charged with criminal trespass, theft by taking, and another count of criminal trespass. You also have 25 CR 001485Y, in which you're also charged with theft by taking and criminal trespass. Do you wish to move forward and take a plea today? I need you to speak as loudly as possible. Is that a yes? I'm sorry, I still can't. Is she unmuted?
Your Honor, I think she's unmuted, but they have.
Go ahead. You want to take a plea, Miss?
Yes, I do.
You want to take a plea? Okay. You have an absolute right to remain silent. You have a right to an attorney, and I am conducting this hearing by video. That means other members of the public can log on and watch this proceeding today. Do you understand your rights and how I'm conducting the hearing today? Okay, thank you. Ms. Falk? You're muted.
On Miss Gilliard's first case, the theft by taking and criminal trespass, the state's recommendation on that case is going to be 12 months, serve 158 days. She will receive credit for time served for 79 days. So this will be a time served plea. Well, she will be released. And then that is for March 19th, 2025. She will have a stay away from the Georgia Tech campus on count 2, 12 months serve 158 days, credit for time served 79 days, stay away from Georgia Tech campus, no further contact with Elizabeth Sinyard, and $70 in restitution to Miss Sinyard. The second case on the calendar on count 1, 12 months serve 158 days, credit for time served 79 days from March 19th of 2025. That is to run concurrent with 25 CR 001464. Count 2, 12 months serve 158 days, credit for time served 79 days, balance probated, stay away from Georgia Tech campus, no further contact with Millette Handley, and that is also going to run concurrent with count 1. As to her cases, Your Honor, the facts, if these cases were to go to trial, is that on the incident that happened on October 2nd of 2024, the defendant went into the nanotechnology building at Georgia Tech at 345 First Drive. She was seen taking Miss Millette's property, which included a Discover credit card, Nike keychain, some Chime cards, a teddy bear, and an LGE card. The value of those items were $350. The victim's credit card was then used at the Dairy Queen in downtown Atlanta. And she was then again seen on February 12th, 2025, going into the Clough Undergraduate Living Center, going through the belongings of the other victim and taking the items from the victim. She was then later apprehended on that case. And so that is the basis. As far as the I believe as far as the restitution is concerned, that is to her first case. And
Is
the
that
restitution,
that was the cash that was taken?
so the second case is the one where she took the credit card. The other case where the restitution is attached, that case happened on March 19th of 2025. She was sitting in the lobby and rummaging through the personal items of our victim. And I believe she took $70 and a Snap Fitness card, which belonged to Miss Elizabeth Sinyard. She was observed removing the cash and the Snap card from the wallet and then later discarding the wallet as she exited the building. The victim was able to locate her wallet, but stated the $70 and the Snap Fitness card were missing. An additional search found $48.10 hidden in her underpants. That was not returned to the victim. So that's why we are asking for the $70 in restitution.
Okay.
And we would like to sound for Miss Sinyard and Miss, I believe the other
Hanley, Miss Hanley. Are either of those parties on the line? Okay. Mr. Bartels, is that what you agree to? And do you stipulate to the three elements or no?
Well, we do so stipulate, Your Honor. This would be a non-negotiated plea. It looks like, well, she served 79 days in jail. I would submit that that's a sufficient penalty for this. I do understand what the basis of the request for the restitution is, but that is that's the only condition of any probation. Ms. Gilliard is unemployed. She's been in jail for almost 3 months. We're advised that she was on disability at one point, but is not currently. So she has no income. And I think, it would just be setting her up to fail to require the restitution to be paid back, especially after she served 79 days. Well, I think it'll be 80 days by the time she gets out. So she understands, when I talk with her, she understands she has to stay away from all Georgia Tech property. She can't go back there, but we would just ask for credit for time served and the balance suspended with the stay away and no further contact.
And Your Honor, I would just advise that perhaps you would like to hear the defendant's history before making that determination. She does have 23 cycles.
You can tell me the history, Ms. Falk.
Yes, Your Honor. So as I stated, Ms. Gilliard has 23 cycles. The last two were these cases. She has a 2024 probation violation out of Sandy Springs, 2024 failure to appear, a 2024 criminal trespass out of Clayton County, a theft by taking, criminal attempt to commit a felony in April of 2017. She does have a criminal attempt, a theft by taking December 14th of 2023. She did enter a guilty plea to that in Fulton County State Court. She also has a failure to appear, a theft by shoplifting from 2015, probation violations from 2014, a theft of services that she pled guilty to in 2014 in Fulton County State Court, more probation violations in 2013, and then criminal trespass and theft by shoplifting and financial transaction card cases in 2012. I would just need to see what the result of those were, because those were in felony court in Fulton County. So
I understand she has a limited history. I mean, extensive history.
And an extensive history revolving around thefts, and particularly financial transaction card fraud, because in one of our cases, she had taken a debit card. They did not charge her with that, but there had also been allegations that she had used a transaction card at Dairy Queen.
Yeah. All right. If she takes a plea, I won't make her pay the restitution. Does she wish to do that, Mr. Bartels? I do understand that. Miss Gilliard, I'm giving you a second chance. Do not, we're going to see if you're going to take this plea. We're going to ask you some questions, okay? All right. Please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury? All right. Speak loud. Thank you. You can put your hand down. Is she unmuted at ACDC?
Yeah, she just has to speak loud.
Speak as loud as you can. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand completely that you're giving up your right to trial by judge or by jury?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you're satisfied with Mr. Bartel's representation here today?
Yes, ma'am.
And you fully understand this proceeding and that you're taking a guilty plea?
Yes.
You said yes?
Yes.
And you understand you absolutely cannot go back to Georgia Tech? Is that a yes?
Yes, ma'am.
All right. And let's see. And you can have no contact with either of the individuals from whom you took these items. All right, Ms. Gilliard, as to the charges of criminal trespass and theft by taking in the case ending in 1464Y, how do you plead? And as to the charge of theft by taking in criminal trespass in the case ending in 1485Y, how do you plead? All right, I accept your guilty plea. Is there anything additional from the state or the defense?
Nothing from me. Thank
All
you.
right, that concludes your case, Ms. Gilliard. Do not go back to Georgia Tech. All right, you absolutely can't do that. Best of luck to you. You're getting a second chance today. Bye-bye.
Is it still balance probated? Judge?
Is balance suspended.
Balance suspended? Okay, thank you.
Thank you, Your Honor.
All right, so I believe we concluded the entire calendar.
Yes, Your Honor.
Your Honor.
One more thing, I'm sorry. For Ms. Dunford, she decided she wants to go ahead and take the plea. For Ms. Dunford?
I know I think we're gonna still reset. I don't have good feelings about that. I think Ms. Dunford is still gonna be, well, okay, Ms. Dunford, come forward. Do you wish to take a plea today, Ms. Dunford?
Yeah.
You sure? Now a few minutes ago you told me you wanted to plead not guilty and go to trial. So what changed in the past few minutes, Ms. Dunford? We're gonna reset this case 1 week. I'm not gonna take this plea today. I don't feel that that is appropriate. Okay.
I will see you before court, Ms. Dunford, okay?
All right. All right. I believe we've completed the competency calendar. I see someone on here with the last name Davis. Miss Davis, if you want to turn on your camera, the case, if you're here for, are you Miss Tamika Davis? Can you please turn on your camera? Are you here for Santuan Davis?
Yes.
All right, that case will be reset 1 week, okay?
1 week. Okay.
All right.
Yes, ma'am. Do you have the exact date?
1 week from today, the 12th.
June 12th.
Yeah, I'll be in touch with you, Ms. Davis, before court next week.
Okay.
Okay?
Okay, thank you so much.
All right. The competency calendar, SAP, and DV reset calendars will all be in recess until next week. Oh, no, I'm sorry, until Tuesday. So take care, everyone. Please send your orders to Mr. Jordan so I can get them signed. Have a good afternoon.
I will. Thank you.
Okay, bye-bye.